Workplace concerns, especially bullying, are becoming increasingly prominent, and every employee deserves to be treated with respect and fairness. Hi, my name is Aryan Gupta, and I'm a paralegal in the Employment Department. Today I'll be discussing a critical issue in employment law, which is constructive dismissal. If you're feeling mistreated by your employer and considering leaving your job, you might wonder whether you can claim constructive dismissal. In this video, I'll break down what constructive dismissal is, when it applies, and how you can build a strong case if you're affected. At its core, constructive dismissal occurs when an employee feels forced to resign because of their employer's bad conduct. This might include altering contract terms without your agreement, persistent bullying, or harassment. Imagine if your employer suddenly reduces your pay or drastically changes your role without your consent. Such actions can make you feel trapped, undervalued, and compelled to resign. That's where constructive dismissal comes into play. It's important to distinguish between unfair dismissal and constructive unfair dismissal. Although they're related, they are distinct. Unfair dismissal occurs when an employer terminates an employee's contract without a fair reason or proper procedure. This can lead to settlement agreements or tribunal claims. On the other hand, constructive unfair dismissal arises when the employee decides to resign due to the employer's actions. While the employer hasn't explicitly dismissed the employee, their conduct essentially forces the resignation. To succeed in a constructive dismissal claim, you must prove three key points. First, there must be a serious breach of your employment contract. Second, your resignation must be in direct response to that breach. And third, you must act quickly. Delaying your resignation could imply that you've accepted the breach. Key triggers to look out for include unplanned employment changes, for example to your role or hours, a hostile work environment, or if you face retaliation for raising concerns about the workplace issues, and ongoing oversight from your employer. If you believe you've been constructively dismissed, it's crucial to build a strong case. You can do that by documenting everything, for example, by keeping emails or letters that highlight any misconduct, or securing witness testimonies from colleagues who can attest to your experiences, and also seeking legal advice before resigning. An experienced solicitor can help you to understand UK employment laws and provide a tactical legal strategy. They can also help with gathering evidence and can provide you with emotional support. Remember, if you're considering a constructive dismissal claim, time is of the essence. You must act swiftly as claims need to be submitted to an employment tribunal within 3 months minus 1 day from your dismissal date. Before you file a claim, it's mandatory to engage with ACAS for early conciliation. Only after obtaining the early conciliation certificate can you proceed with your claim. For employers, it's crucial to foster a positive work environment to avoid potential claims. This means clearly defining employment terms, addressing workplace concerns promptly, and encouraging open communication. A harmonious workplace benefits everyone, reducing the risk of claims like constructive dismissal and promoting a thriving company culture. If you're facing constructive dismissal or need advice, don't hesitate to reach out. You can call us on 0207 940 4060 or visit our website for more information. Thank you for watching.